Welcome all to LawSikho's thorough newspaper analysis for 9th of February 2024. Now, we'll be starting with the today's agenda of the day. We'll be discussing about the scheduled class sub-classification and the various judgment from Punjab and the Punjab High Court and from the Andhra Pradesh High Court as well. We'll be discussing about the quota benefits, and this particular editorial, we have taken it from the Indian Express. And as per our schedule, we'll be discussing the news update and lastly, the legal news update of the day. So let us start with the today's editorial session, where the context of this particular editorial session is coming from a 7-judge constitution bench, which is headed by Chief Justice of India, D.Y. Chandrachud, reserved judgment in the sub-classification among scheduled caste case. Some states have argued that despite reservations, some castes are grossly underrepresented in comparison with the so-called dominant scheduled caste. And they wanted to create a separate quota of such castes within the scheduled caste quota of 15% to ensure that the benefits are adequately distributed. Now, there was a 5-judge bench in the year 2004 by the, constitution bench in E.B. Chennaiya versus State of Andhra Pradesh, which held that only president could notify which communities could reserve reservation benefit as per Article 341 of the Constitution, and that states did not have the power to tamper with this. Now, the number of states have now returned to the Supreme Court to argue against the Chennaiya decision, claiming that states do have the power to make such reservation benefits as distributed to communities that need them the most. The respondent, on the other hand, defended the Chennaiya judgment and argued that all scheduled castes must be treated equally. Now, the beginning happened with the Punjab government notification in the year 1975, which classified and divided its 25% SC reservation at the time into 2 categories. The first category seats were reserved solely for the Balmiki and Mazhabi Sikh community, which were and continue to be considered 2 of the most economically and educationally backward communities in the state. Now, under the policy, they were given first preference of reservation in education and public employment. The second category consisted the rest of the scheduled caste community. Now, this notification remained in force for almost 30 years. And the legal hurdle started in the year 2004, in which a 5-judges bench struck down a similar law which was introduced by the Andhra Pradesh in the year 2000, and it was struck down to the E.V. Chennaiya versus State of Andhra Pradesh judgment. The law contained an expansive list of scheduled caste community in the state and the quota of reservation benefit provided to each of them. The court held that the subclassification would violate the right to equality by treating communities within the category differently, and said that the scheduled caste list must be treated as single and homogeneous group. The rationale was that since the constitution classifies certain castes in a schedule as they historically face discrimination due to untouchability, they cannot be treated differently from one another. The 5-judge bench held that this means state did not have the power to interfere or disturb this list, including the subclassification. 2 years after the apex court ruling, the Punjab and Haryana High Court in Dr. Kishan Pal versus State of Punjab struck down the 1975 notification. Now, the appeal went in October 2006. After the Punjab and Haryana High Court struck down the notification, the Punjab government attempted to bring back the law by passing Punjab Scheduled Caste and Backward Classes Act 2000. The act reintroduced the first preference in reservation for the Balmiki and Mazhabi Sikh communities. But in 2010, the Supreme Court once again struck down the provision. In 2014, the Supreme Court in the Davinder Singh versus State of Punjab referred the appeal to a 5-judges constitution bench to determine if the 2004 E.B. Chennaiya decision required reconsideration, since it needed an inquiry into the interplay of several constitutional provisions. Now, in 2020, the Constitution Bench, which is headed by Justice Arun Mishra, held that court's 2004 decision require reconsideration. The ruling noted that the court and the state cannot be silent spectator and shut its eyes to stark the realities. The ruling disagreed with the premise that scheduled castes are homogeneous group and said they are unequals within the list of scheduled caste, scheduled tribe, and socially and educationally backward classes. Crucially, since E.V. Chennaiya decision, the concept of creamy layer also trickled down to SC's reservation. In the landmark 2018 ruling in Jarnail Singh versus Lakshmi Narayan Gupta, Supreme Court upheld the concept of creamy layer within the SCs too. The creamy layer concept puts an income ceiling on those eligible for reservation. While this concept applies to OBCs, it was applied to promotions of SCs for the first time in 2018. Now, since the Davinder Singh bench was also 5 judges, a larger 7 judges bench is now hearing the issue, and only a larger bench judgment can prevail over the decision of a smaller bench. And let's see what happens to the subclassification and quota benefits in SCs. Now, uh, now this has happened. Okay, now the arguments of this particular thing that happened. So apart from Balmikis and Mazhabi Sikhs in Punjab and Madida in Andhra Pradesh, Paswans in Bihar and Jatwas in UP and Arundhatiyas in Tamil Nadu will also be impacted by the subclassification category. Now, the most important thing about the argument from both the sides. Now, the Advocate General of Punjab, Gurminder Singh, argued that the E.V. Chennaiya was mistaken when it was held that states could not tamper with the classes that comprise the presidential list under Article 341. Highlighting the language used in 16.4 of the Constitution, he pointed out that article allows the state to provide reservation for backward classes who are not adequately represented in state services. As the phrase used is not adequately represented in the state services. Now, Singh argued that there is no obligation to provide the same opportunities to every community in the presidential list. Now, former Attorney General K.K. Venugopal also made a rare return to the court to argue in favor of subclassification. Recalling his experience arguing Chennaiya case, he stated that without subclassification, the weakest sections of society will be left behind, defeating the very purpose of reservation. Now, senior advocate Sanjay Hegde, appearing for the respondent, argued that all community included in presidential list suffered from the taint of untouchability, and the Constituent Assembly made a choice not to enter into comparisons of who suffered the most. He then claimed that if a community named in the presidential list did not receive reservation benefit, they would only be left with the stigma of being a scheduled caste. Another intervener similarly argued that states did not have the discretion to ignore some scheduled castes in favor of other. The bench took note of this point, and CJI Chandrachud acknowledged that the court would have to lay down criteria to ensure popular politics does not affect the granting of reservation. So this was some arguments which is done by both the sides, and let's see what the larger bench, which is 7 judges bench, make on this point. Now, Sharad Pawar's faction gets new name day after Ajit camp declared real NCP. A day after it recognized the faction led by Maharashtra Deputy Chief Minister Ajit Pawar as the real Nationalist Congress Party, the Election Commission has allotted the group led by NCP founder Sharad Pawar the name of Nationalist Congress Party Sharad Chandra Pawar for the upcoming Rajya Sabha elections in Maharashtra. While passing its final order in the dispute between two sides, the ECI had asked Sharad Pawar to send a list of 3 preferences for a name to be used by the factions in the election to 6 Rajya Sabha seats. Maharashtra government decides to introduce Chief Minister Vayoshree Yojana. So the Maharashtra government has decided to introduce Chief Minister Vayoshree Yojana that is likely to benefit 15 lakh senior citizens who suffer from physical or mental disability. The citizens above the age of 65 years will be screened, and they found eligible will be paid 3,000 rupees. A proposal in this regard was approved by the Maharashtra government. Uttarakhand becomes first state to clear Uniform Civil Code Bill. So, Uniform Civil Code Uttarakhand Bill 2024, which seeks to govern and regulate the law related to marriage and divorce, succession, living relationship, and matter related thereto, was passed in Assembly following a 2-day discussion. The bill will now be sent to President Draupadi Murmu for her assent. Uttarakhand is now poised to become the first state to get a common law on marriage, divorce, land, property, and inheritance from all the citizens, irrespective of their religion. The code, however, will not apply to scheduled tribe. Government launches mobile health service, Kilkari, and mobile academy in Maharashtra and Gujarat. Now, Union Ministry of State for Health and Family Affairs virtually launched the Kilkari program, mobile health initiative for beneficiary in local content in Gujarat and Maharashtra. Mobile Academy, a free audio training course designed to expand and refresh the knowledge of accredited social health activists and improve their communication skills via their mobile phones, was also launched. El Salvador Bukele's claimed landslide election win. El Salvador President Nayib Bukele has declared himself the winner of national election that revolved around the trade-off between security and democracy. Bukele on Sunday claimed to have won more than 85% of the vote despite electoral authority not yet releasing the official results. El Salvador, officially the Republic of El Salvador, is a country in Central America. Capital is San Salvador. Currency is Bitcoin and United States dollar, and official language is Spanish. Justice Vijay Bishnoi sworn in as the Chief Justice of Guwahati High Court. The Assam Governor Gulab Chand Kataria administered the oath of office to Justice Bishnoi. It is to be noted that Supreme Court Collegium, via its resolution dated 27th of December 23, recommended the name of Justice Vijay Bishnoi to be the Chief Justice of Guwahati High Court. The central government, by notification, appointed Justice Vijay Bishnoi, Judge of the Rajasthan High Court, to be the Justice of Guwahati High Court. Now, coming up to the legal update, subcategorization of SCs and ST can help more classes, but guidelines needed to avoid play of popular politics. So again, the editorial is related to this particular topic, where the court have said that subcategorization could be a measure to ensure that the benefits of reservation reach the more backward category within the reserve category. Now, 7 judges bench will observe this particular judgment, and the court has observed that if only certain castes are cornering the reservation benefit, it can lead to inequality. And let's see what the judgment comes. Can't be permitted to contradict initial position to create substantial question of law. Andhra Pradesh High Court dismisses second appeal. So Andhra Pradesh High Court has dismissed a second appeal filed holding that the parties cannot blow hot and cold and cannot be permitted to approbate or reprobate at the same time. The court had held that to be a substantial question of law, there must be a foundation for it led in the pleadings, and the question should emerge from the substantial findings of the fact arrived at by the courts of fact, and it must be necessary to decide that substantial question of law for a just and proper decision of the case. Now, guys, if you want to revise your previous TNA, then do attempt the daily quiz link that is mentioned in the description of this particular video. If you like this video, do share with your friends and family members. Thank you so much for watching. Take care.